Welcome back to Go Ask a Nurse, where professionals who care bring you the insight you didn't know you needed. I'm your host, Anna Marie, a nurse, educator, advocate, and a believer in empowering patients through knowledge. Today, we are diving into one of the most important and often overlooked topics in healthcare, the legal protections every aging adult and family should have in place, but often don't. My guests today are two father-daughter duos, Kent and Sarah Endacott. I am so excited to dive into this conversation with them about living wills, the power of attorney, Medicaid planning, and how to legally prepare for the unexpected before a crisis hits. Whether you're a nurse, caregiver, or aging adult, this is information that can truly change lives. So let's dive in. Welcome. Thanks so much for being here. Can you tell us a little bit about how you got into law?
Well, I guess I come from a family of attorneys. My father's an attorney, now retired, and my uncle was an attorney and a district court judge for some 30 years here in Lancaster County. And so I guess I thought maybe I'd continue the family tradition.
And I'm Sarah, the daughter. Yes, we're in Lincoln, Nebraska, and so I am from a family of attorneys in Lincoln, Nebraska, and I thought, well, gee, I'm at least as smart as my dad, so if he can go to law school, then I can too. And that was pretty much most of my decision.
What made you both specialize in this particular kind of law?
I always sort of wanted to do tax and trust and estate work and estate planning. And so I sort of emphasized that in law school and then got out, started practicing. And I can tell you that I learned that an ounce of prevention is a pound of cure in the estate planning and elder law arena. Because when I was a young lawyer, they made me do contested guardianships and conservatorships. And so that's kind of how my practice eventually morphed into more true estate planning and administration and some tax work.
I would say I have always been close to my grandparents, but I also realized I loved and was close to my friends' grandparents. So I thought, my dad's an estate planner. I really have a heart for the elderly, and so I'm going to try this. And then being a legal intern at an estate planning firm kind of encouraged me to seek out trust work because in some ways it feels like as the actual estate planner putting the documents together, you're there in times of crisis, but as a trust officer who gets to be there for the whole picture, I'm there for the fun stuff too. So it's more relational. And so, yeah.
It's definitely a topic that we don't always think about until later on in life. And definitely as a nurse, I've seen that death has no age. And it's something that I think is very educational for everybody to start learning. So what legal documents should every adult have in place when it comes to their health decisions?
Well, a lot of times the most important document that people will do is a healthcare power of attorney. And a healthcare power of attorney is a document that authorizes a person designated, called an agent, to make healthcare decisions in the event you cannot. A healthcare power of attorney can be a very simple document, it can be more complex, but what a healthcare power of attorney does is allows that person that you've picked before you've become incapacitated, that you trust to make healthcare decisions. It avoids a process known as guardianship, and we can talk about that later. But and a healthcare power of attorney can include additional items, but it doesn't have to. It can include items where you appoint a funeral agent to make funeral arrangements, and also can include an advance directive.
So I think of some of these younger people that are coming in, let's say they come into the hospital and they didn't realize how sick they are and they don't have any of this put together. Is there something that you can do directly there at the hospital that will make it legal?
Yes. The Nebraska statutes include a statutory short form healthcare power of attorney. And most medical providers will provide that. And that is a document that, if it complies in substance with the statute, is valid as a healthcare power of attorney. And that's commonly, provided. And that's bare bones and not nuanced. So people, it's better than nothing, but I encourage people to have custom drafted healthcare powers of attorney. For example, a lot of elderly differ in their opinion on whether they should stay in the home and spend money on home health care. Or some will say, no matter what, you're not taking them out of this home, in which case we even hardwire it in. And then we can get an advanced directives, but a healthcare power of attorney can be combined with an advanced directive as well.
Can you explain the difference between a living will and a healthcare power of attorney?
Yes. A healthcare power of attorney is a statutory device where the principal, the person signing the document, authorizes an agent to make healthcare decisions for them upon incapacity. There is a Healthcare Power of Attorney Act in Nebraska, and that Healthcare Power of Attorney Act includes certain safeguards, such as it cannot become effective until there's been an opinion by either your treating physician or any attorney hired or any physician hired to consult with regard to the incapacity. So if there's an opinion that incapacity has occurred, then the healthcare power of attorney kicks in, and decisions such as authorizing medical treatment, surgeries, those can be made by the agent under healthcare power of attorney. An advance directive, sometimes called a living will, is a document that is written in the first person, and it is a statement by that person that they do not want certain procedures taken to prolong their life. And there's, again, safeguards built into the statute. It authorizes these things. And then it also, the statute says that if a medical provider follows the directive, the proper directive, they're really indemnified and held harmless for following that. So that's an advanced directive or a living will. And they can either be a separate document, a lot of times we refer to those as a living will, or they can be included in a healthcare power of attorney. The advanced directive is often part, but not always, of the healthcare power of attorney.
Is there one that trumps the other?
You want to make sure they're consistent. I've had some people, if you have language, the difference is really this. If I put it in my healthcare power of attorney, I'm asking an agent that I appoint, family member, friend, to make that decision on the ground. If I make that forward-looking living will statement, then there's no intermediary to interpret what's going on in the ground. The reason a lot of times you see it done as part of a healthcare power of attorney is there's some religions that prefer that. Canon law under the Roman Catholic Church authorizes advanced directives subject to some canon law nuance as long as they're in a healthcare power of attorney. They do not like separate living wills.
So for example, I recently got married and I have a healthcare power of attorney, which names my husband, but it says follow the rules of my religion and please respect my wishes in that. And is part of the document.
How can families ensure that their loved ones' medical wishes are respected if they become incapacitated?
I think it helps to be really clear with your family before there's an emergency and get the documents in place. And often people, and especially parents, don't want to share their wishes with where they'd like their assets to flow with their kids. But I would say, and maybe your opinion differs, but it can be very helpful to send the document because you can make as many originals, as many copies as you want. And so people are really clear about it. My husband is obsessed with this show called The Pit, which is like a medical show. And so I often say to him when we're watching the show, if this is me, let me go. I think just honestly talking about it with your family and having those difficult conversations beforehand.
Failure to discuss it's a big problem and to act on it. Not having a healthcare power of attorney is just a disaster if the situation occurs, because the alternative is not good. The alternative is a court proceeding called a guardianship.
Well, it's definitely hard to have those conversations, but like you said, it is really important to have them because we definitely want to follow their wishes and would rather know their wishes now when they're in sound mind than when they're not. What happens if someone becomes incapacitated and has no advance directives in place at all? Like, who makes those decisions?
Well, that is where you have to have a guardianship. Even under the law of most states, including Nebraska, if you have a longtime spouse, they don't have legal authority to make medical decisions for you to determine your health, your treatment, your living arrangements. That is a proceeding called a guardianship, and that involves a great deal of expense, loss of, in certain loss of time, and in certain cases, loss of privacy. You can ask the court to have closed hearings, but it's not always granted because there's a strong public policy for open courts. So a guardianship is the alternative, and it's not a good one. It's really where you don't ever want to intentionally have a guardianship. You want to have in place powers of attorney.
So I just want to make sure I understood this correctly. So if I was incapacitated and I have not filled out or did anything, my spouse would not?
I'm afraid your spouse would have to go file in court, and if it was an emergency, for a temporary order of guardianship, you'd have an appointment. Then there would be a proceeding where, if you don't really think you need it, which a lot of times happen, you're entitled to get your own attorney, and they're arguing sometimes for what you want, not your best interest. So it can be, as a veteran of a lot of these contested guardianships, it's not good for the incapacitated party, it's not good for the family, and it's expensive.
Wow.
And so really, and the same goes for asset management. There's an asset management power of attorney that also should be put in place, because if you don't have an asset management power of attorney and you become incapacitated, that's a conservatorship proceeding. Or if there's no conservator, the guardian acts as the conservator, manages money. And even if it's a long-term marriage, there still has to be a bond posted. You have to file all financial records of that person every year. You have to go to training, which is required by the Nebraska Supreme Court. So it's just really a failure to plan is a big problem.
I'm just thinking how so many people out there don't know this information, and one thing we never plan are accidents or random things that take us way too early.
Right.
And nothing is planned. This is great information. What are the best ways to prepare legally and financially for long-term care or nursing home needs?
I like to say that the best way to plan for that is to talk to the people who are experiencing it. So phone a friend who is in a nursing home or has a relative in a nursing home, and they will tell you the astronomical price. And I mean, in Nebraska, it's easily $10,000 a month on average per facility, and more so if you're there with your spouse. We're living longer than ever, and we're not pumping out as many nurses from the colleges as I would hope that we start. And so I think care, just in that regard, is going to get more and more expensive. And so I think, first of all, planning ahead and being reasonable about longevity in the modern age and the financial ramifications of that.
Yeah, I think that there's a lot of ways to approach it. One approach is to simply use the traditional risk mitigation product, which is insurance. There's a traditional long-term care insurance that people should look at, consider. It's a financial decision, but it can be a very valuable asset. So people can look at just insuring against that risk. And it used to be that there were, when this whole product long-term care came out years and years ago, they didn't know how to underwrite it. So there are a lot of policies out there where the underwriters got out of the business, but still right now there's several solid carriers in the business, and that's one way to do it. And there's options with regard to long-term care, because you can determine, do I want the best policy, which would pay from day one when I meet the definition of incapacity, or can I self-insure? In other words, do I have some liquidity and an income that could pay for a waiting period, be it 90 days or 180 days? So I encourage clients to look at that as part of the planning process. They may decide we'd rather self-insure, and in some cases that makes sense, but you got to make sure you have liquidity, calculate your Social Security earnings, earnings from retirement plans, and see if it can be cash flowed without having to sell assets. There's other techniques that we could talk about, such as gifting a remainder interest in assets to children, but that might be beyond the scope of what you want me to talk about.
I had a client this week who told me he is canceling their policy that they've paid hundreds of dollars every month for years, and said, I wish I had self-insured and just put this money in an investment account, because a lot of these long-term care policies are just horrible to try to get into practice. So I've done that on several occasions, and they're insurance companies, so it's a lot of paperwork and it's a lot of proof. So it can be perfect in the right situation, but you have to meet like certain activities of daily living to qualify, and the packets for the policies are really long. So there's definitely two options, but almost a financial advisor needs to get in the picture.
Right, and due diligence is necessary. Ask around, because there's a lot of really wonderful advisors that approach it holistically and consider that, and suggest that as part of an option, as part of your overall financial plan. And then there are just some people that are out there that are disreputable and just want to make a sale of a product that you wouldn't really want years later. So unfortunately, the elderly are vulnerable to a lot of con artists, and if they're not open and honest with their kids and have a dialogue, that makes them even more isolated and vulnerable. So it's a difficult situation, and some people don't have children to lean on. So
they're trusting the people that they're talking to as they consider experts that could just be taking advantage of them, which is unfortunate. Can you explain how Medicaid planning works and why it's important to start early?
In a nutshell, the rule is that we have to pay for our own care before the government does, right? That's the general rule. So Medicaid planning can be fairly complex. It involves trying to reduce assets to the point where you become eligible for benefits. There's a lot of misunderstanding out there. If you have a spouse, and because the odds are both spouses aren't going to become incapacitated at the same time, there's a statute called the Community Spousal Impoverishment Act, and that sets out, based on inflation-adjusted numbers, certain assets that can be retained by what we call the community spouse. That's a spouse that, let's just say, stays at home, and the other is the spouse that needs the care. And what they'll do is they'll spend, if it's a married couple, they'll spend they'll basically take their assets and divide them in half. And I think the community spouse that won the state of the house gets certain exempt assets, such as a house. The government won't take a house while a spouse is residing in it, a car, about a small amount of prepaid burial insurance. And then, that's really the assets. So spending down and planning for Medicaid eligibility involves, thinking up front of what would happen, worst case scenario. For example, okay, if we get our assets divided in half and I have this house, can I maintain this house? So a lot of times we encourage people to look at living in a house that you could actually live in and take care of. A house is an exempt resource, so is a car. If your car is getting old, and you're worried about this, make sure you have a good car. Make sure your house has a good roof. That's converting what we call available resources under the Medicaid regulations to exempt resources. And then you divide it in half, and the maximum the community spouse can be spent down to is about 167,000 under the current.
Like 157.
Yeah,
Adjusted for inflation.
157, and then the other spouse that's in the nursing home that can be spent down, but they keep the house, and then that exemption amount. Now, once they no longer can live in the house, then they can be spent down to the $4,000 level. But
it's very technical, and it's good for people to get resources and counsel, especially regarding Medicaid planning.
And there's a lot of free resources online, so.
Is there like a certain age that people should start looking into getting advice and planning?
You never want to make decisions with end of life and asset transfers in an emergency. You want to have it all done beforehand. And I mean, I would say that's a good time to say, when do you need those documents? Because a lot of my friends have young children, and I say, this is the time.
Yeah.
Put in your documents who's going to take care of your kids if the worst of the worst happens.
Absolutely. What legal protections exist to help a healthy spouse keep their home or assets when the other spouse needs nursing home care?
Well, that's the Community Spousal Impoverishment Act, and that's where certain exempt resources can be kept, such as the house, one house, a car, and other miscellaneous, such as the pre-need burial. And one thing I would caution people, I've seen this before, is that house, in order for it to be eligible, has to be in both spouses' names, or one spouse, or the other, but you can't have kids on it. So that I've seen people where they add the kids to the house, and what they've done is accidentally made them ineligible for the Community Spousal Impoverishment Act exempt resource protection. So I don't think a transfer on death deed applies to that. So but those are relatively new devices, the transfer on death deeds in Nebraska within the past 10 years.
Are you saying that if parents are adding their children to the houses and that's not the way to go, should everything be in a trust then?
It could be in a trust or in both spouses' names. Or you could actually do a separate transfer on death deed, which doesn't transfer anything until the second death. And these are technical documents that, but people, the worst thing is just to add son on the deed as joint tenants for right of survivorship. But then that house is not eligible for the community spousal protection.
The titling of the property is like very important to what the government sees when they're looking at if you're within the rubric for that spousal impoverishment number. So mistitling certain assets, especially your house, has very dramatic consequences.
At what point should someone consider seeking legal guardianship for an elderly loved one with dementia or Alzheimer's?
It becomes obvious that they are having trouble caring for themselves. A lot of times you'll notice hygiene is slipping, can't drive anymore safely. A lot of times it's necessary to talk to the physician, if they will talk to you. But a lot of times you don't have access if there's no healthcare power of attorney, and then you have to go to the guardianship route, which is unfortunate. But
I've got clients with both of those things, and if someone puts their assets in funds of trust and that makes sense and uses a corporate fiduciary such as Union Bank, people like me who are trust officers file their taxes, pay the nursing home, pay all other bills, manage real estate. So as the bank, a bank actually can serve as your financial power of attorney. And so that is one way to pre-plan, is to think, if I don't want to leave a child to manage me, if I've gotten this terrible diagnosis or it runs in the family, setting all of that up early and building a relationship with the corporate fiduciary can be a good thing too.
I have to say that's an excellent point, even if you are my daughter. A trust is a management tool, and a trust is like your common revocable trust is a tool where you put assets in it, and it includes management rights for the successor trustee to take care of the settlor, the person establishing the trust. And so really, if you do have assets in a trust and there's incapacity of the settlor, it is a lot smoother transition to have, as Sarah says, a corporate trustee step in, or somebody else. So that is, one thing we think about. A revocable trust, while we're on the subject, a lot of clients say, do I need a trust or a will? Well, it depends. A trust is a will substitute. It can pass assets at death according to its terms, but it's also a management tool. And I think it's good to keep that in mind, as Sarah reminded us. Plan in place and documents that could be acted upon quickly in the event, such as a trust and powers of attorney that we talked about, which I think are, a lot of times, the most important documents that people do. A lot of times they say, I want to do an estate plan. We haven't done it. And they think that just consists of a will. So if you have a power of attorney, you have somebody authorized by law that has to be respected under the Nebraska statutes that can intervene. If you don't, again, you have to go to court. You can get, a lot of times, with the elderly, as you know very well, the decline is not a steady decline. It's not a continuum. Sometimes they're good, sometimes they're bad. And I've seen where we've had contested guardianships, and guess what? They were well rested. They were, the hearing was in the morning. They seemed fine. So that's the risk you have if you don't plan.
What advice do you have for adult children who want to start these conversations with their aging parents but don't know how?
And I think that the most important thing is these conversations have to first occur if there's more than one child, so that you have one unified front, if possible. And sometimes you just have to say, I hate to tell you this, but you've told me the same story 3 times in 5 minutes here. And they can react poorly to it, or they can react, it just depends. But I, again, start as early as possible.
I think it can be especially difficult in the case of a second marriage, making sure everybody's kids are taken care of, both from the current marriage and the prior marriage. And I think that's a lot of times when we see a lot of conflict, and when kids have difficulties amongst themselves, if they haven't really talked to their parents about these sorts of things, it can be very difficult at the end. What I like to say is my job is great because people can still have Thanksgiving dinner at the end of the day. If mom and dad die and some lady named Sarah at the bank gets to be the one doing everything and tells us what's what, then we can all be mad at her together instead of the siblings fighting amongst themselves, because sometimes mom and dad were the ones that managed everything. And I also think when you plan early and you use a corporate fiduciary or a trusted partner, then you're not elevating one kid higher than the other. So at the end of mom and dad's life, one kid isn't doing everything and being the boss and just telling their siblings what's going to happen when. It's a third party.
I would agree with that. I see that a lot where there's, sibling rivalry comes out and is exacerbated by a document that names one child, not the other, rightly, wrongly. And certainly every family is unique, but that is, corporate trustee does solve a lot of that problem.
My youngest brother said to me, well, obviously I would be in charge of that someday. And I thought, do you even know I went to law school and this is all I do every day? So
I'm smarter at this than you.
Yeah, dang it.
What are the most common financial mistakes people make when planning for healthcare costs in retirement?
They're just not doing a liquidity analysis and not figuring out how they could potentially cash flow it.
How do you guide families who have children or aging parents with special healthcare needs?
But I mean, most people should have a will, and often it is often the case that a trust makes sense. A lot of people fund their trust with their home, they fund their trust with their real estate, and then it is secure. I mean, a revocable means you can revoke it. So if you put your house in trust and it's in the ABC trust, you still own your house inside that trust. It's like a legal terminology.
Yep.
Sort of. So both are very important. And then, like I said, it'd be the will that would dictate where you'd like your children to go if something were to happen to you.
That's right. If you have minor children, you can specify in a will the guardian.
I'm at the age where a lot of my friends are having children, and I'm like, please do this. It's so important. Don't let the worst thing to ever happen to your children mean they also have to go to court with grandma and grandpa if something were to happen to you.
What's one piece of legal advice every caregiver or nurse should know when working with older adults?
Encourage them to have a healthcare power of attorney and an asset management power of attorney. They're not complicated, expensive documents, but they can sure. And I don't care about how wealthy or moderate your means are. They're probably, a lot of times I tell my clients when they come to see me, I want to do in my estate plan, they want to talk about the will, and I talk about, well, do you have powers of attorney? And a lot of times they think, well, we just want a will. And then I explain, well, this asset's in joint tenancy. A will wouldn't control. This asset, your retirement, you've named a beneficiary. These assets are all in joint. There'd be no probate. We should do a will, as a good planning. But the most important documents you're going to have are your powers of attorney in case you become incapacitated. And they never really think about that. So the more we get the word out, then it's just,
The sooner they start planning, the better off they'll be.
right. And I will tell you, I should mention, when I first started practicing law, which I'll tell you was 31 years ago, guardianships and conservatorships were not as onerous. About some time back, there was a whole bunch of fraud that struck mostly in Nebraska and in Douglas County. And in response to that, Nebraska adopted a uniform act that's a lot more stringent. And that's why guardianships and conservatorships are really nothing you ever want. It's a failure to plan that leads to them, in my opinion. So
my thought is, especially with DNRs, like do not resuscitate. I had an experience with a relative who said, the facility I'm living in wants me to sign this. I think I want to be resuscitated, don't I? And she's an octogenarian. And I just kind of said, well, the facts on the ground, as I understand it, is that at your age, if they have to bring you back to life, they might break 3 to 6 ribs in the process. So just understand that if they bring you back, it's not going to look the same for you, and you're going to be limited in your healing journey. And as soon as you say that to people who ask me, it really changes their perspective. So I think healthcare practitioners have the most knowledge in that area as far as practicalities and what that actually looks like.
I appreciate both of you for taking the time to answer these questions and to really educate us on looking ahead at what we should be doing and starting to do now. I really enjoyed this conversation and have learned so much, and I hope everybody else has enjoyed as well. I thank you again for your time.
Thank you.
Thank you again, Sarah and Kent, for sharing your expertise. I know we always think we have time to start planning. We always think we have the next day, or until at least we get older. We've learned how living wills, trusts, and other legal documents are not just about protecting our assets. They're about protecting your voice and your family's future. Not wait until a crisis happens to make these decisions. Take action now. Reach out to a trusted attorney or a personal trust and wellness management officer to make sure your wishes are kept. I have linked Sarah and Kent's information on goaskanurse.com below the episode podcast 10. And as always, keep asking questions and keep advocating for you and your family. Be blessed. The information provided on this podcast is for general informational and educational purposes only. It is not intended to be a substitute for professional medical advice, diagnosis, or treatment. Always seek the advice of your physician or other qualified health provider with any questions you may have regarding a medical condition or health concern. Never disregard professional medical advice or delay in seeking it because of something you heard on this podcast. The views expressed by guests on this podcast are their own and do not necessarily reflect the views of the host or Go Ask a Nurse.